Hi, everyone, and welcome to KCAB International's webinar titled Perspectives from Korea on Commercial Disputes Involving Korean and Chinese Parties, presented to you as part of the Hong Kong Arbitration Week. So today the topic is something that has always been of keen interest to many commercial parties in Korea, but has not been so much discussed in previous webinars or other seminars. But the importance of commerce between Korea and Chinese parties is of such importance that it deserves more focus, especially if you consider the potential disputes that may arise from it. For today's topic, we have an array of very impressive speakers. I will introduce them in more detail as they start their presentation, but just to give you a run through of the speakers that we have today, we have Kellie Yi of the Seoul office of HKIAC. We have Sejin Kim, who will be speaking from Bakem and Lee. We have Jae Min Jeon, who will be speaking from Shin Kim, and then we will have Sun Kim, who is a partner at Lee & Co. Jae Woo, who is also a partner at Yulchon, and finally, but not lastly, Joel Richardson, who is now working at Kim & Chang. So they will come all in sequence, and the first speaker we have in line is Kellie Yi, and just to give you a short bio of her impressive past. Kellie is counsel and chief representative of the KCAB Seoul office, and prior to joining KCAB, she worked at Allen Overy, based in Hong Kong, and she also has experience as a senior in-house counsel at Hyundai Heavy Industries in Korea. In fact, one of my past clients, and as in-house, she managed both non-contentious and contentious matters involving cross-border litigation and international arbitration. Kellie's experience in international arbitration spans Europe, Middle East, and Latin America, and Asia, and involves major institutional rules and also the UNCITRAL ad hoc proceedings. She specializes particularly in construction and commercial disputes, and including those involving under the EPC contracts, procurement, security agreements, joint ventures, and whatnot. All right, so with further ado, I'll ask Kellie to start her video and give us her presentation. Thank you, Kellie.
Thank you, Sue, for your kind introduction. Let me put up my slide first. So good morning, everyone. As Sue has mentioned, my name is Kellie Yi, and counsel and chief representative of Seoul office. Sue has mentioned that the international commerce between China and Korea is of an important topic, and it definitely is. And there's a long history of trade and international commerce between China and Korea. So just taking a look at the last 10 years, you can see a gradual increase in transactions between the two countries and the importance of one country to another. To give you some statistics that is provided on the slides, as you can see, in 2019, it reached a record high in export and import, and of nearly 500 billion USD of goods exported from Korea, 125 billion USD worth of goods was sent to China. So that's a huge number. That is a quarter of all exports sent to China. And China has always been, in the last at least 10 years, top 4th export and import country to Korea. So before the COVID pandemic, the #1 foreign visitor to Korea was from China and vice versa. This shows that there is a huge reliance on not only trade, but tourism, gaming, and technology, which I discussed in a previous HKIAC webinar, which can be found on our website, and other industries as well. So unavoidably, there are going to be many changes that have been and will come about by the COVID-19 situation. But I think the important role of China to Korea and Korea to China in international trade and transactions will most likely remain the same or increase with time. Now, when there are international transactions, disputes are unavoidable and bound to happen. And what I would discuss today is a tool available in resolving in disputes in arbitration forum to save time and costs dealing with these Korea-China disputes. So the two that I mentioned is interim measures arrangement. I would like to briefly introduce the interim measures arrangement for those who are less familiar with it. In a nutshell, what the arrangement is an agreement between Hong Kong SAR government and Supreme People Court of Mainland China, allowing parties to an arbitration seated in Hong Kong to seek interim relief from mainland court. So to give you some important dates to start off, in April 4, 2019, the final text of the arrangement was signed in Hong Kong between the two governments. September 25th, 2019, HKIAC was recognized as a qualified institution. And the most important date is October 1st. That's when the arrangement came into force. So we received at HKIAC our first application before October 1st. So people have been waiting to file this arrangement as soon as it came into place. But since the arrangement requires the filing to have been made on or before October 1st, we worked with the parties to have it resubmitted. So the arrangement is a groundbreaking development and a very important strategic tool that parties can use before and during a dispute has already arisen, as this was not previously possible. So before the arrangement came into place, in China, interim measures arrangement was only possible in an administered arbitration seated in China, and the application had to be granted only by the interim courts. So you cannot still file for an interim measures application to the tribunal. And if you do, the tribunal has to go to the courts to get it granted. So now we have access on the mainland to preservation of assets, evidence, conduct, and a party can file the application anytime and during, before and during an arbitration proceedings, as long as it is before an award is issued by the tribunal. Now, one thing to note is that if you file an application before filing the actual arbitration, you have to file the arbitration within 30 days of the interim measures application. So to give you some of the statistical overview of application we have received since the arrangement has come into force, we have processed 32 applications to date. Applications were made in the following interim courts, as you can see on the slides. All applications have been received for matters which arbitration proceedings have already been commenced. Out of the 32, 29 were for asset preservation applications, 2 for evidence preservation, and 1 for conduct. The total amount of applications that for preservation of assets was in the realm of 1.6 billion USD. Successful applications granted by the mainland courts total about 1.3 billion USD. So that's a very high number to be granted. Most applicants are foreign parties, but one notable thing is that over 53% of respondents are foreign parties. What that shows is that it's not, these interim measures arrangement applications are not only used significantly for Chinese parties, but also for foreign parties who have assets in China. As you can imagine, not only Korean companies, but foreign companies from all over the globe have some form of assets or investment in China, whether it's a factory or whether it's a branch office or whatnot. And as you can see, 53% of respondents have been foreign parties in that realm. Now, there has been some concern with Hong Kong, specifically in the last year, due to protests and new national security law that was put in place. But the security laws have been implemented in a very limited case, and Hong Kong continues to remain a strong and safe seat for arbitration. Now, with this new interim measures arrangement and enforcement agreement between Hong Kong and China, which has been in place for quite some time, Hong Kong has been a very pro-arbitration jurisdiction, and it continues to be so. Completely different legal system between China and Hong Kong. As you know, Hong Kong is a common law jurisdiction, and China is a civil law jurisdiction. And Hong Kong arbitration law is based on 2006 Yulchon model law, and China's arbitration law is not. So the court system and also the court systems in Hong Kong reflect more of an international court rather than a local court, as over 15 non-permanent judges are from overseas. So the current judges seated are from, I think, 10 from the UK, several from Australia, and also from Canada. Obviously all common law jurisdictions. And these judges are the ones that are deciding for any of the applications that relate to arbitration matters. So this I've already dealt with. One thing I also would like to note is that now with the COVID-19 situation, we have seen a large increase of hearings conducted virtually, both partially and fully virtual. Last year during Seoul ADR Festival Week, which is almost a year now, HKIAC and KCAB entered into a cooperation agreement. Now you can have an arbitration seated in Hong Kong, but conducted in SIDRC or vice versa. More pertinent, this agreement is more important and pertinent in the COVID-19 era. And now that there's virtual hearing capabilities available, you can have the arbitration seated in Hong Kong, but have it conducted in the Seoul office. We have already had cases in which this agreement has been used. And I think it's a huge benefit for parties that want to arbitrate a case as seated in Hong Kong to reap the benefits of intermeasures arrangement or enforcement arrangements with China, but be outside of Hong Kong, specifically in Seoul, SIDRC to conduct the hearing, and that is available. Another great benefit of this cooperation agreement is that there's a discounted rate available for parties using this arrangement, which will be determined on a case-by-case basis. So one thing to keep in mind when you are arbitrating HKIAC under the HKIAC administered rules. And if you have any questions regarding the agreement or any of the topics that I have discussed today, please feel free to email me. And we also have more information on our website. Thank you.
Thank you, Kelly. Thank you for the very well prepared presentation. I really could relate to the statistics that you started your presentation with, the trade volume of parties of cases involving Korea and China. Like for example, in KCAB's caseload, we have statistics on the non-Korean parties who are involved in KCAB cases, and parties from the US and China are usually neck to neck when it comes to first and second place. I currently think we have a little more higher number of US parties, but a few years ago we had more Chinese parties involved in newly filed KCAB cases. So that was also something that I could relate to. Okay, so for the next speaker, we have Sejin Kim, who will be talking about joint venture disputes and the related issues that can arise in disputes involving Chinese and Korean parties. And to give you an introduction to Sejin, Sejin is a senior attorney at Baker Lee, and he has more than a decade of experience in both international, commercial, and investment arbitration cases. And those cases were under various rules such as the ICSID, the ICC, SIC, HKC, UNCITRAL, and of course KCAB. Sejin has advised multinational corporate clients navigating cross-border litigation, both in the US and Korean courts. He is an active US qualified lawyer who also has earned the distinction of completing law degrees in Korea. Sejin is often quoted as being ideally placed to assist both domestic and foreign clients in international litigation mandates in both US and Korean courts. Sejin is currently leading Baker Lee's e-discovery and investment practice team, and is actually the co-founder of that team, where he actively assists his clients in handling extensive forensic and e-discovery processes that is required in both US litigation and international arbitration. So, well, we'll hear from Sejin. Thank you, Sejin.
So can you see my slides? Sue, can you hear me well? All right, how about the slides? Okay. All right, thank you. I'm Sejin Kim, as Sue introduced. I'm a senior attorney at Beckman Lee, and today I will briefly talk about a form of dispute arising from the typical investment arrangements involving Korean companies in Chinese market. I chose this topic because it seems that a joint venture arrangement is frequently used by Korean investor who decides to open their business in the Chinese market. Personally, I think I am quite lucky enough to have had chances to advise a few Korean companies that were involved in each possible stage of commercial arbitration against the Chinese companies under JV agreement. So today I will try to give you an overview about how such joint venture investment are made by Korean companies in China, and then through a few exemplary cases I have experienced, I will try to explain how dispute resolution would be unfolded through arbitration. One of the most typical joint venture structure used by Korean investors in China is called the Sino-Foreign Equity Joint Venture, especially when they need to cooperate with the Chinese partners to run business. Given that this structure involves both foreign and Chinese investors, this is distinguished from a concept called wholly foreign-owned enterprise, under which no collaboration with Chinese parties is expected. Under this type of venture, a Korean investor usually put more than a quarter of the total investment, while there is no minimum requirement for Chinese counterparts. Another important concept is called a variable interest entity, more often called a VIE. So this means an entity which controls a Chinese company based on various contracts, so that a foreign investor can justifiably have a business control over the business, which would be otherwise banned because of such business is only open to Chinese companies. So one good example that I have seen for this VIE arrangement was found in a home shopping industry in China, where one of our clients was involved. This complex chart of business structure shows how a Korean company made investments in a home shopping business in China together with their Chinese counterparts through Sino-Foreign Entity joint venture and VIE structures. In this case, they established a joint venture here by contributing capital, money, and then Korean companies could not directly, because Korean companies could not directly operate a home shopping channel under Chinese law, these two Chinese companies established a separate domestic company to operate the business upfront instead of contributing assets to the joint venture. So in the same vein, the Chinese companies provide a broadcast license, like here, which was not available to the Korean partners. In return, the Chinese companies received the majority shares. So this structure enabled the Korean companies to directly run home shopping business in China, which would be otherwise unavailable. So under the structure, these entities here would produce home shopping content and send them to the regional cable network to broadcast them in a designated region of China. As usual, old couple would sometimes think about their divorce at some point of their marriage. So while the JV in this case was established in October in 2011, both Korean and Chinese investors envisaged their sad future in their JV agreements like this. In other words, if JV fails to strike a balance on a cumulative basis within 5 years after its establishment, they will proceed to liquidate it. And if any dispute arises, then let's go to arbitration under KCAB rules. And in November 2015, this is how the dispute was unfolded. In November 2015, which was slightly shorter than the envisaged 5-year period, the sad event actually occurred. The Chinese investor alleged that JV failed to strike a balance within 5 years. But the Korean JV partner said, no, the JV struck the balance and the 5 years has not been lapsed yet. The JV was established late 2011 as defined in the JV contract, and now it's only 2015. But Chinese partner said again, no, the company was established in late 2010 when it was first incorporated. So this issue of whether JV was established in 2010 or 2011 became an epicenter of their fights, legal fights. Then they negotiated to settle their dispute, but in April of the following year, in 2016, the Chinese partners terminated the JV contract all of a sudden. On this basis, the Chinese parties took away the domestic company's corporate seal, which was the most important instrument required for all transactions, and just stopped the entire operation of the JV overnight. They also fired the employees and stopped transmission of the JV contents to the cable network. So the Korean party had to think about how to save their business from this abrupt Saturday massacre, which occurred in a single night. So they opened the contract and found the arbitration agreement, but they needed to be very quick. That's why they applied for an interim relief through emergency arbitration, in which they requested Chinese joint venture partners to return the business to the status prior to the purported termination of the contract. So as a council of the Korean parties, we appointed the emergency arbitrator under KCAB rules and filed the pleadings by walking through the famous three-pronged test for interim relief. So first, we have a prima facie winning case given the elements for termination of the contract have not been met. The situation is so urgent as to receive a quick order, otherwise all employees will be laid off overnight and the entire business will stop. And this will seriously harm the business reputation, customer relationship, which is really core asset of the home shopping business. So we asked the emergency arbitrator to order that the business be restored to the normal status very quickly, and that this request was granted within a week since we filed the application for the emergency arbitrator. But unfortunately, the respondent Chinese JV partners did not comply with this order, so we had to really expedite the proceedings to proceed to the main arbitration by presenting our argument, almost the same argument, to the main arbitral tribunal. So in the main arbitration, we basically request the same request for relief, but because about 2 years had already passed over the course of the arbitration, our client was placed in a situation that the pursuit of normal business would not be meaningful. So accordingly, they changed their request for relief from the specific performance to damages claims, which the tribunal granted in entirety. But again, the Chinese JV partners were not compliant with the arbitral word. We were a bit scared because at that time there was a rumor that an international arbitration word might not be well enforced by Chinese courts. But we sensed the Chinese judiciary was changing, we've changing, to a status that actually they are more inclined to enforce the arbitral word, especially the international arbitration word. And so we filed an application for recognition and enforcement in Beijing court. In response, the Chinese parties did a jurisdictional defense, which was dismissed, and they appealed. But the High Court affirmed the lower court decision, all of which took about a year. Then we could bring back to the case to the substantive phase where the Chinese party alleged the arbitral word's breach of the public policy of China, given that the Chinese government prohibited them from transmitting the JV home shopping content because they were licensed to broadcast only one content under the policy named one channel, one content policy, which means the Chinese party should broadcast their own contents and, So under that argument by just asserting that argument, they said that basically Chinese party should broadcast their own contents and they don't want to give up theirs. And also plus they cannot broadcast JV's content on top of theirs. But the JV contract specifically said that if this one content policy matters, you should give up yours. In other words, the JV's content should be broadcasted instead. And this was one of the legal bases that the arbitral tribunal adopted in making its decision for our clients. And the Beijing court also accepted this position. Therefore, about a year later, since we first filed the application for recognition and enforcement, the court finally granted the application and the respondent finally complied their order in a few months. So in overall, it took about 1.5 years to receive the Beijing court, the Chinese court's order for the reinforcement, for the recognition and enforcement of our arbitral tribunal. So it took about like 2 or 3 years from the beginning to the end of the entire dispute to settle the difference between the parties. So I believe that these courses of action that I just walked through show every possible option that we can consider for dispute settlement when we face disputes arising from JV joint venture arrangement in China. So to summarize, this typical form of joint venture arrangement would include possibly the emergency arbitration phase and main arbitration phase based on the decision of the emergency arbitration. And then if the losing party does not accept the result and is not really compliant with the award, then we can proceed to the enforcement phase, which is quite easier than before, I guess, in China, in Chinese judiciary. So I hope that this is helpful, for the Korean company who consider dispute resolution with their Chinese counterpart in their business. Thank you.
Thank you, Sejin. Thank you for the presentation. It must have been a very challenging case, but at the same time, I'm glad you had a very favorable result, and it must have been a very rewarding experience. Okay, so next in our presentation is a presentation on arbitrator selection, evidence taking, advocacy, and other procedural issues, all our favorite subjects. And this will be presented by Jae Min Jeon. So Jae Min is a partner partner at Shin Kim, and he is the head of the firm's International Dispute Resolution Practice Group. Jae Min has represented large corporate clients in international commercial arbitration cases and treaty investment treaty arbitrations arising out of various transactions, such as cross-border M&As, inbound or outbound investments, etc. Jae Min also served as a director of international affairs for the Seoul Bar Association, and he has published various articles on topics, on arbitration-related topics, including in publications such as GAR Know-How, Getting the Deal Through, and Foreign Investment Regulation and Review. So with that, I will turn the mic towards Jae Min. So Jae Min, go forward. Thank you.
Thank you, Sue. Let me begin with a question. Is there a clear, stark difference between arbitration case involving Chinese party and other cases? Well, I do not think there's a such difference that everyone can agree to in terms of procedural aspects. For instance, if we have a HKIAC arbitration or ICC arbitration seated in Hong Kong or Singapore with sophisticated parties, well-experienced counsel, and well-respected arbitrators, then there's not much difference between a case involving Chinese party and case involving foreign parties from other jurisdictions. Actually, this is why international arbitration is gaining popularity and has such a universal application to disputes that involve different parties from different countries. However, when it comes to an arbitration that is seated in China and administered by one of the Chinese arbitration institutions, such as CTAC or HKIAC, pursuant to arbitration rules of that institution, one must heed to a few key features of the local law and local rules that are mandatory and that can be different from the ones you are more familiar with. So let me first touch upon several features one can often encounter while being engaged in an arbitration with Chinese counterparty. Some Chinese parties may not be familiar with the IBA evidence-taking rules, and they tend to be more used to the Chinese judicial system and the civil procedural law of China. That is premised on the principle that the party who pleads a certain fact should submit its own evidence rather than seeking evidence from the other party. This is similar to the Korean evidence rule at Korean court proceedings. Therefore, you may not be able to obtain as much evidence as you would like from the Chinese counterparty through a document production request. The only remedy available in this situation, in a practical sense, would be to ask the tribunal to draw an adverse inference against the Chinese party. With this in mind, I would advise that the parties be more careful and cautious when formulating the request for document production to the Chinese counterparty. As a related note, the issue of who will be responsible for or bear the cost for the translation of documents produced or submitted as evidence can be an important issue. Sometimes the translation of voluminous documents can be time-consuming and very costly. Some of those documents will be in Korean and others will be in Chinese. Therefore, a counsel may need to discuss with his or her client before agreeing with the other party on this issue and before setting out the relevant rule in a procedural order. Now, when we do CTAC arbitration or HKIAC arbitration or other cases administered by Chinese Arbitration Commission, a number of points may appear to you as unique. For instance, if there's no agreement between the parties as to whom to select as the chair of the tribunal or as their sole arbitrator, the Arbitration Commission, the institution, will designate the chair for the case. The Arbitration Commission selects the chair from the list of arbitrators it maintains. Although the pool has expanded a lot and gained more diversity, there still remains uncertainty about who the Arbitration Commission will designate. In some cases, someone will be selected as a chair you do not have much information about, or who you have no experience working with before. And that chair may not be fully accustomed to generally accepted international arbitration practice. More importantly, the arbitration law of China provides that when there's a dissent among the members of the tribunal, the chair will be given the sole power to decide on the issues instead of using the majority rule. Also, you may encounter more frequent jurisdiction challenges that may be raised by Chinese opponents. The ultimate power to decide on the jurisdiction of the tribunal belongs to Chinese court. Therefore, if the parties cannot or do not agree to adopt the competence principle, then the jurisdiction challenges may end up in Chinese court proceeding, which may obviously cause significant delay and cost to the dispute resolution. 2 points on advocacy. First, the Chinese arbitration law provides that the parties must have the right to make oral arguments. It further states that the presiding arbitrator or the sole arbitrator must solicit final opinions from the parties. Because of these provisions, and because these provisions are considered mandatory law of China, it may be difficult to skip the closing statement or closing argument at the hearing, or to replace closing statement with post-hearing submissions. Second, the tribunal may tend to adopt more of an inquisitorial approach than an adversarial approach. If that is the case, counsel need to be well prepared for the questioning, sometimes unexpected questioning, that may come from the tribunal. Lastly, I can't emphasize enough the issue about language. In a CTEC case, if the agreement does not provide for arbitration language, then the default language is Chinese. The language of arbitration would directly affect the pool of arbitrators you can select from, the counsel your client should retain for the case, the need for interpretation of your witnesses and expert statements, and also translation. So in sum, most of the time, it will be smooth sailing, even though you have a Chinese party in arbitration. And the procedural issues will not be that much different from other institutions' rules. However, as mentioned earlier, it can turn into a bumpy road. And in order to avoid this as much as you wish, and without regrets, you need to learn how to draft a good dispute resolution clause in an agreement with a Chinese party. It can be your blessing or your curse. With that, I will end my presentation. I will turn the screen over to Sonia, who will speak about a dispute resolution clause. Thank you.
Thank you, Jae Min, and thank you. We're ready to introduce Sun Young to the audience, but just wanted to say that I couldn't agree more that as long as you have a good sailor and a good captain, it will be smooth sailing when it comes to international arbitration in disputes involving Korean and Chinese parties. Okay, well, so I guess it's time for us to introduce Sun Kim, who will talk about dispute resolution clauses in China-related arbitrations. So Sun Young, if I can give everyone a short introduction of who she is. Sun Young is a partner at Lee & Co.'s International Dispute Resolution Group, and she acted as counsel in various international arbitration cases brought before the ICC, the SIC, CTAC, and KCAB, as well as ad hoc arbitrations. And prior to joining her current firm, Lee & Co., Sun Young gained experience in cross-border joint ventures, M&A transactions, and related disputes in various major U.S. law firms. So with that introduction, let me turn the floor over to Sun Young. Oh, there she is. Hi, Sun Young.
Hi, thank you very much for your introduction. So I will talk about some considerations to keep in mind from the perspective of a non-Chinese party when drafting an arbitration agreement with a Chinese party. If a foreign party is to agree on arbitration with a Chinese counterparty in China, the foreign party should bear in mind the mandatory rules that govern arbitrations in China. And a unique mandatory rule in China is that ad hoc arbitrations in China are in principle prohibited, with a limited exception applicable to arbitrations in the Shanghai Pilot Free Trade Zone located in Pudong. This principle stems from Article 16 of the Chinese Arbitration Act, which provides that an arbitration agreement must designate an arbitration commission that will administer the arbitration. So if a foreign party is to agree to arbitration in China, it should in principle pursue institutional arbitration as opposed to ad hoc arbitration. And I understand that the most commonly used Chinese arbitration institution by foreign parties is CTAC. And second, with respect to arbitration language, it is advisable to provide in the arbitration clause that English, or at least Chinese and English, shall be the arbitration language. In CTAC arbitrations, if the arbitration language is not expressly stated in the arbitration clause, there is a risk that Chinese may be designated as the official language of the arbitration. This is because the CTAC arbitration rules provide for Chinese as a default arbitration language, while Article 81 of the CTAC arbitration rules states that CTAC may designate a language other than Chinese as the arbitration language. After considering the relevant circumstances of the case, CTAC may still designate Chinese as the arbitration language, even in an arbitration involving a foreign party. And this is what happened in a CTAC arbitration case that I worked on. In this case, we represented a Korean company in an arbitration against a Chinese company, and the arbitration agreement was silent on the arbitration language. We requested that English be designated as the arbitration language because our client is a foreign company, and making Chinese the official arbitration language would prejudice our client. However, it was decided that Chinese would be the arbitration language on the grounds that the Chinese counterparty objected to our request for English to be the official language, and Chinese is the default arbitration language under the CTAC arbitration rules. So for CTAC arbitrations in particular, foreign parties should require that arbitrations be conducted in English. This is important because the arbitration language affects the constitution of the arbitral tribunal. And one thing that I observed about Chinese arbitral institutions is that they seem to expect a high level of Chinese writing proficiency from even wing arbitrators, where Chinese is designated as the arbitration language. So if Chinese is designated as the arbitration language, it is likely that all members of the arbitral tribunal will be Chinese nationals. And third, in relation to the constitution of the arbitral tribunal, it is recommendable to require a tribunal of 3 arbitrators as opposed to a sole arbitrator, because this will allow the foreign party to nominate an arbitrator. It is also advisable to require that the chairman be of a nationality other than that of the parties, because Chinese arbitral institutional rules, such as the CTAC arbitration rules, do not provide for any restriction on the nationality of the chairman. In addition, parties may consider stating in their arbitration clause that arbitrators who are not members of the arbitral institution's panels of arbitrators may be appointed in order to ensure a broader choice of arbitrator candidates. And where a foreign party is to agree on arbitration with a Chinese counterparty outside of China, the foreign party should bear in mind that under Chinese law, only foreign-related disputes may be arbitrated outside of China. Would you please turn on to the next slide, please? According to Article 128 of the Chinese contract law, domestic disputes must be arbitrated in China. And a dispute is foreign related if at least one of the parties is foreign, at least one of the parties habitually reside out of China, the subject matter of the dispute is outside of China, the legal facts that lead to the establishment, change, or termination of the transaction occurred outside of China, or there are other circumstances under which the transaction may be deemed foreign related. In the 2014 case of Beijing Shaobai Sheng Sports and Leisures versus Beijing Shua Wing Xuan Investment Consulting, a recognition and enforcement of a a Korean Commercial Arbitration Board award was denied because the dispute was not foreign related. In this case, a wholly foreign-owned enterprise registered in China, which is considered as a domestic company under Chinese law, entered into a contract with a Chinese company to operate a golf course in China. The contract included an arbitration clause stating that disputes between the parties shall be submitted to the Korean Commercial Arbitration Board for arbitration. And after a dispute arose between the parties, an arbitration was commenced and the parties obtained an award from the Korean Commercial Arbitration Board. The winning party sought enforcement of the award in China, but the Supreme People's Court of the PRC held that the arbitration clause was invalid on the ground that the dispute was not foreign related and rejected recognition and enforcement of the KCAB award. By contrast, in the 2015 case of Shanghai Golden Landmark versus Siemens International Trade, the Shanghai court took a more lenient approach in finding the foreign elements. In this case, two wholly foreign-owned enterprises established in the Shanghai Pilot Free Trade Zone entered into a sales contract to be performed in China. The sales contract contained a dispute resolution clause for arbitration in Singapore. And although the parties in this case were wholly foreign-owned enterprises, which are considered as domestic companies under Chinese law, unlike in the Beijing Shaolanxing sports leisure case, the Shanghai court found that the dispute between these companies are foreign related and the arbitration clause was valid. One of the main reasons was that these companies were incorporated in the Shanghai Pilot Free Trade Zone, which has a policy of encouraging foreign trade and investment, and thus should be treated differently. This Shanghai Golden Landmark case seems to have opened the door for Chinese courts to interpret foreign elements more broadly. However, it remains to be seen whether Chinese courts will also adopt a broad interpretation for cases that involve companies that are not incorporated in the Shanghai Pilot Free Trade Zone. Therefore, a foreign party should continue to consider the foreign-related dispute requirement under Chinese law if the foreign party intends to agree on an arbitration outside of China and later enforce an arbitral award in China. Thank you, and now I would like to give the floor to the next speaker.
Thank you, Sanyang, for the presentation. I'm glad you mentioned the Beijing Shaolai Shinseng sports case. After that came out, I think the KCAB did a survey of the known cases that were sent to the enforcement stage in Chinese courts. Except for this very outlier exception, most of the KCAB awards were safely enforced in Chinese courts. So somehow it's a bit of a case study as being a very exceptional case. But as you mentioned, there are certain legal requirements that parties need to be aware of. So thank you for that. And we're ready to introduce the next speaker, who is Jae Hyung. And to give you an overview or a short introduction of who he is, Jae Hyung is a partner in Yulchon LLC, and he specializes in international arbitration and cross-border litigation. Jae Hyung also advises clients in various issues relating to international trade. And prior to joining his current law firm, Jae Hyung worked at the Korean Ministry of Justice, where he focused on trade agreements, investment treaties, and legal service markets. Jae Hyung received an LLM from the London School of Economics and Political Sciences, and he was seconded to Pinson Mason's London office prior to returning to his current firm. So with that, I will introduce Jae Hyung and his topic, which will be recent developments in China's enforcement of arbitral awards. So Jae Hyung, the floor is yours.
Thank you for your introduction. Hello, my name is Jae Hyung, and I am a partner at the International Dispute Resolution Team of Yulchon LLC. Yulchon is a full-service law firm based in Seoul, and we have an office in Shanghai as well. Naturally, we have a strong Chinese practice team that often cooperates with the International Dispute Resolution Team in various disputes related to China. So in the next 8 minutes, I would like to introduce you to the recent developments in enforcement of arbitral awards in China. Yes, next slide, please. Compared with foreign court litigation, arbitration would be a more attractive way of dispute resolution for Korean and other foreign parties in terms of enforcement. This is because China is not a party to treaties that provide for the enforcement of civil judgments given by the courts of its major trading partners, including Korea. In theory, Chinese courts can enforce foreign judgments on the basis of reciprocity, but in practice, very few foreign judgments have been recognized and enforced by Chinese courts in this way. A judgment rendered by a Korean court cannot be enforced in China. Likewise, a judgment rendered by a Chinese court is not enforceable in Korea. In the case of arbitration, as you are well aware, China is a member state of the New York Convention, together with over 160 other countries, including Korea. Thus, arbitration awards made in these states can be enforced within China, and arbitration awards issued in China is enforceable in Korea and other signatory countries as well. However, many people tend to say that enforcing arbitral awards in China is a challenging matter. Although some problems seem to exist, in recent years, China has been making various efforts to promote an arbitration-friendly environment and reduce the perception of judicial protectionism. In regards to this, I will discuss some recent developments regarding enforcement of arbitral award in China. Before taking you to my first point, I would like to briefly discuss about 3 different types of arbitration proceedings and awards in China. Similar to Korean Arbitration Act that distinguishes between foreign and domestic arbitration for recognition and enforcement purpose, China separately regulates foreign arbitration and domestic arbitration as well. China also distinguishes these types with foreign-related arbitration. This distinction is significant because the legal basis and procedures for enforcing the award resulting from these types are different. Awards rendered in foreign arbitrations can be enforced under the New York Convention, while awards rendered in domestic arbitrations and foreign-related arbitrations are enforced in accordance with the arbitration law and civil procedure law of China. These are known to be subject to stricter scrutiny by the Chinese courts. A foreign arbitration is an arbitration seated outside China. As Hyun just mentioned in her presentation, a case without any foreign aspect, even if seated outside China, can not be treated as foreign arbitration and be enforced under the New York Convention. I would just like to add that arbitrations seated in Hong Kong, Macau are essentially treated as foreign arbitrations. However, arbitral awards made in Hong Kong and Macau can be enforced in mainland China based on mutual arrangements, and they are not enforced under the New York Convention. A domestic arbitration is one involving only Chinese parties with no foreign element. Both domestic arbitration and foreign-related arbitration are seated in China and administered by a Chinese arbitration institution in principle. The difference between them lies in whether there is any foreign element in the dispute. As provided by the Supreme People's Court, pursuant to the Supreme People's Court's interpretation, a foreign-related arbitration must have at least one of the foreign elements shown in the screen. As it is required to select an arbitration commission to have a valid arbitration agreement under the arbitration law, and the traditional view was to interpret this arbitration commission as Chinese arbitration institutions only, there have been some uncertainties over whether parties can choose a foreign arbitration institution to administer a case in China and whether awards resulting from China-seated proceedings of one of these foreign arbitration institutions can be recognized and enforced by Chinese courts. In addition, it was also unclear whether the awards will be enforced as which among the three types of arbitration if they are to be enforced. Next, please. In 2009, Ningbo Intermediate Court granted enforcement of a China-seated ICC award. This case was known as the first reported case of an ICC award seated in China to be enforced. In 2013, court confirmed the validity of an ICC arbitration agreement seated in China. However, despite these decisions, uncertainties have been still remained, and there were conflicting decisions by courts. Recently, two judgments by intermediate courts in Shanghai and Guangzhou have further clarified these issues. In June this year, Shanghai Intermediate Court confirmed the validity of an arbitration agreement providing for HKIAC arbitration seated in Shanghai. More importantly, in August 2020, in a dispute between a US seller and a Chinese buyer, Guangzhou Intermediate Court held that an award rendered in an ICC arbitration seated in Guangzhou could be enforced in China as a foreign-related award, and the award should be enforced under the civil procedure law rather than under the New York Convention. It still remains whether higher authorities, including the Supreme People's Court or the lawmakers, will take further steps to confirm the enforceability of awards resulting from arbitration seated in China, but administered by foreign institutions. But the recent trend clearly shows that the court's effort towards an arbitration-friendly judicial environment. Next slide, please. Instead of going through the grounds for each type of arbitration under the New York Convention or the Civil Procedure Law, I would like to introduce a very unique system in China, the so-called reporting system, which applies to all three types of proceedings from 2018. In order to ease the resistance of the Intermediate People's Court with respect to the enforcement of arbitral awards ruling in favor of foreign parties, the Supreme People's Court established a reporting system in 1995. Recently, by the Supreme Court's judicial interpretation in 2018, this system was further expanded to arbitral awards made in China. Under this reporting system, if an Intermediate People's Court intends to refuse enforcement of an arbitral award, before ruling on this issue, it must first inform the High People's Court of this situation. If the High People's Court also finds that enforcement is not to be granted, it must refer the issue to the Supreme People's Court for approval. The Intermediate People's Court cannot refuse enforcement until the Supreme People's Court has given its approval to do so. A recent research done in Korea shows that this reporting system has been actually effective. For 20 years since China introduced the reporting system in 1995, only one decision out of 17 cases that the Intermediate Court refused enforcement based on the public policy ground was known to be approved by the Supreme People's Court to do so. As shown in the screen, it is the Supreme People's Court's position to adopt a narrow interpretation of public policy ground under the New York Convention. So the reporting system will especially play a significant role on controlling intermediate courts decisions. However, despite this reporting system, intermediate courts decision refusing the enforcement may lead to delay and abuse of process because no timeline has been specified for the reporting and approval procedure. Next slide, please. For my last topic, I was planning to discuss on the groundbreaking change for interim relief, of course, in mainland China for Hong Kong-seated arbitrations. However, as Kelly already introduced this development in detail and much better than what I have prepared, I see no need to go over this topic again. I would just like to add that Despite this change, the court's interim relief for arbitration seated in Korea or any other places except Hong Kong is still not available. Therefore, a party who is worried of taking the risk of dissipation of other parties' assets in China, or who wants to place more pressure on the opposing party when settlement is needed, and still want to have an arbitration outside mainland China, then Hong Kong seated arbitration would be a preferable choice of seat for the party. So this is the end of my presentation. I hope you find my presentation interesting and helpful. Thank you very much for your kind attention, and please feel free to contact me if you have any questions. Thank you.
Thank you, Jae-Hyung. That was a very succinct and very well-organized presentation on the topic. So for our last speaker, we have all the fun stuff. This will be presented by Joel Richardson, and he will talk about settlement and mediation, cultural issues arising during Korea-China commercial disputes. And to give you a brief introduction to Joel Richardson is a partner in the International Arbitration Cross-Border Litigation team at Kim & Chang, and he leads the firm's North American arbitration desk. Joel is a US licensed attorney who started practice at one of the largest firms in Washington, D.C. He has practiced international arbitration and mediation with Kim & Chang for the last 14 years, and he is a specialist mediator of the Singapore International Mediation Center. Joel is one of our arbitrators in the KCAB International Panel of Arbitrators, and we had the pleasure of appointing him or observing him serve as an arbitrator in our KCAB international cases. So with that, I'll turn the floor over to you, Joel.
Great, thank you. So we'll conclude the formal discussions, at least, with a bit of a change in speed, going from litigating or arbitrating disputes to mediating disputes. And you may have noticed it's hard now to have an arbitration conference without the mediation topic coming up. And through this discussion, I'll first of all explain why I think that's become prevalent now and why there's a promising future for mediation. I'll then discuss what mediation techniques are prevalent in Korea and China, and then a little bit about how those compare with mediation techniques that are prevalent in the US and I think also in Europe. And then I'll conclude with some final thoughts on what we can take from all of that. So if we look at the next slide, we'll see really what has been driving a lot of the recent discussion of mediation in the international disputes community, and that is the signing of the Singapore Convention on the 7th of August, 2019. On that day, at the signature ceremony, at that point, there were 45 signatories. And I've included here the full description from the Singapore Convention's website of what it's intended to do. But really the key takeaway is the part that I bolded. The point is to enable formally mediated settlement agreements to be internationally enforceable, which just makes this really part of the three-pronged approach of the international disputes community to making disputes more easy to settle on an international basis. And that is the New York Convention that we're all familiar with, the Singapore Convention that is intended to give similar treatment to mediated settlements, and then the Hague Judgment Convention, which is still pending, has not yet entered into force. As you can see, the Singapore Convention did enter into force on the 12th of March of this year, when it was ratified by Qatar, which was the third ratifying country. And we see the next slide. You can see the signatories that are most important, I think, for our discussion today and in this region are Korea, China, Singapore, and the US. You'll note that Japan is not yet a signatory. Most of the major economies of Europe also have not signed the convention yet. And of these key signatories that I've listed, Singapore is the only state that has ratified or acceded to the convention. And you can see below the 6 countries that have currently ratified or acceded to the convention: Ecuador, Fiji, Qatar, Singapore, Saudi Arabia, and Belarus. So it is, you can see a rapidly growing pace, but still a small number. And I think there are high hopes that this will drive more countries to sign on to ratifying the convention, so it will enter into force. But for the time being, disputes between China and Korea remain subject to traditional enforcement mechanisms of mediated settlements, which is the settlement or dispute provision usually included within the mediation agreement rather than an expedited convention settlement. Now, the main topic I want to go over is analysis from a study conducted by the Journal of Conflicts Resolution. And I will caveat this by saying it's a slightly dated study. It compares techniques used in mediation in Korea, China, and Japan. With regard to Japan, it examined studies by conducting interviews of foreign students from Japan studying in the United States, Japanese students in Japan. And those groups both discussed community mediation, and then mediators in Japanese organizations discussed organizational or commercial mediation. And that was combined with data from earlier studies conducted in a similar fashion in China and Korea from 1991 to 1995. And the important point for us is, while a lot of this data related to community mediation, for all three sample sets, a comparative analysis was run that showed that the techniques used had comparable prevalence among both community and organizational mediation, which suggests that those mediation techniques which people learn in the community are the same techniques that they carry over to use in organizational or commercial mediation. So we move to the next slide. We can see the compilation of the data from this study. And this may be difficult to absorb in this format. It's a lot of data in one place, but I thought it helpful to see how this data was compared between the three countries. And then we can look at, on the next slide, 4 particular data points that I think are relevant for users in Korea and China and lawyers advising companies in Korea and China. And I should preface this by saying there are now 3 main types of mediation that are practiced in commercial mediation. Those are a facilitative approach in which the mediator tries to get the parties themselves to propose solutions and discuss their problems with one another to come up with an amicable settlement between the parties. Transformative approach, which is based on a facilitative model, but looks deeper into the underlying needs, interests, and even in appropriate settings, emotional background of the parties with regard to the dispute. And then those 2 techniques are contrasted with an evaluative approach in which the mediator really digs deep into the problem, him or herself, and tries to evaluate the dispute and direct the parties, which is why it's also called a directed approach, direct the parties towards potential settlement points. So you can see here there are 3 points that are essentially evaluative in nature. Those are argue for concessions, which the study defined as the mediator, him or herself, argues for or proposes to one party a specific concession or agreement point. And you can see that's common and a widely used technique among all 3 countries, Korea, China, and Japan. The second evaluative feature is education, or to educate, in which the mediator educates or persuades or advises the disputant about he or she should generally think. So this is really not just an analysis of the disputed issues, but a education of the party as to what is expected from them as a member of society. And in China, these are the first and second most common approaches in the study. And in Korea, they're second and fifth. Surprisingly, the third most common technique found in Chinese mediation was to criticize. And that is perhaps the most evaluative or directive approach. And that is for the mediator to specifically criticize a disputant in almost a personal way, to criticize their actions or their attitude in the process and assign labels such as "you are rude" or "you are being rude." Again, that's the third most common technique in the study in China. It falls to 12th in Korea, which is still, I would think from a Western perspective, much more common than we would expect to see that. And the fourth technique listed here is listen to the other. And that is the mediator has the disputants state their point to him or her. So not the mediator has the parties discuss with one another, but the mediator sits and listens to the parties' dispute and point of view on the dispute. This is something that really bridges the gap between the two. It is more of a facilitative approach because it is the mediator showing empathy and trying to understand not just what's at issue and what the dispute is, but what the disputing party's position and interests with the dispute are. Again, this shows Korea having a somewhat more facilitative approach, with this being the third most common approach in the study and only 13th most common in China. So the key takeaway from all of this is both Korea and China appear to have a more evaluative approach to mediation than facilitative or transformative. And China, even more so than Korea, appears to favor the evaluative approach. If we look at the next slide, we can see a study from the American Bar Association on the techniques that have proved most useful or most effective in mediation in the United States. And this study from June 2017 did not conduct its own independent review and analysis, but you can see examined 50 already existing mediation studies to identify among these various studies what were identified as the most useful or helpful techniques. Pardon me. And all four of these techniques tend toward a facilitative or transformative approach, and that is eliciting the disputant's suggestions or solutions, as opposed to the mediator, him or herself, proposing solutions. Giving more attention to the disputant's emotions and relationships and what the underlying sources of conflicts are. Also working to build trust and rapport with both of the parties, including by expressing empathy or praising the disputants, and structuring the agenda in a way that allows both parties to feel that they're being heard. And finally, I think what is common to the listen to the other technique that was third most prevalent in Korea, using a pre-mediation caucus focused on establishing trust. And this is the mediator, him or herself, will meet separately with each party, where each party has an opportunity to feel that the mediator is listening to them and is not simply someone who is there to squeeze two groups together, but is there to listen to both parties and let them have an opportunity to express their position. So these are the techniques that have proved most successful in the US, and I think Europe has a very similar approach to mediation. And these are certainly different than the study we just looked at with regard to China, and I think also with regard to Korea to a certain extent, which raises an issue for mediation practitioners, both as counsel and as mediators, to try to understand these differences and assess with regard to the specific parties of the dispute, whether it is more beneficial for those parties in that dispute to lean into the approach that they're accustomed to, the evaluative approach, which may in certain cases be the best because trust in the mediation process is important for it to be successful. Or in some cases, it may be useful to, in advance, try to help the parties understand what different benefits can be gained from these facilitative or transformative approaches. But I think that requires participation from the mediation counsel and the mediator in advance to understand the parties and help develop a specific process that meets their needs for that specific case. I think that covers everything I had intended to cover. So I'll turn back to Sue, who I think is going to moderate the rest of the session.
Thank you, Joel. That was a very, very interesting presentation, especially the study between mediation techniques among Chinese, Korean, Japanese parties or mediators. People outside the region tend to lump the three cultures together, but if you look closely, we can see these differences among different cultures and tendencies as well. So that was really fascinating. I think the only thing that we need is a more recent study, because I'm sure societies change and practitioners, the practices change over the years. So it would be good if someone takes time to update that survey or that study. Okay, so we've listened to all our 6 speakers. I hope it was useful. And we have, with the time remaining, we will do a little Q&A session. I'm glad that we have at least, yes, 2 questions from our attendees, and I think we have time for both. The first question is a question to Jae Min, and it relates to the arbitration clauses for China-related transactions. And the question is from Byung-woo Im of Kim and Chang. Thank you for the question. And the question goes like this. You said that the parties should be cautious in drafting an arbitration clause for China-related transactions, in particular to avoid the risk of Chinese courts' involvement in the tribunal's jurisdiction from competence perspective. Okay, so that's the backdrop. The question is there any specific language that you would recommend to lower the risk? And if I may, can I turn this question to Jae Min Jeon?
Sure. This is a very interesting topic or issue. And my short answer would be there's no old cure that can completely resolve this risk. But if you take a look at Article 6 of CTAC arbitration rule, it is CTAC that has the power to determine the existence and validity of an arbitration agreement and its jurisdiction over an arbitration case. However, in its proviso, it says CTAC may, where necessary, delegate such power to the arbitral tribunal. So there is a possibility that even CTAC, in a CTAC case, may delegate its power to determine the jurisdictional issue to the arbitral tribunal. And we see there's a growing tendency of CTAC and other Chinese arbitration commissions to give more deference to parties' autonomy. So to be frank, I haven't seen a contract provision to specifically address this issue, but I have one experience to advise on one of my clients that even though my client was a Korean company, even though they agree to adopt CTAC arbitration as their dispute resolution method, they need to aware of this kind of risk, and they may come up with other language. For example, you can even refer to the specific article of the CTAC arbitration rule and say that the parties refer any issues relating to the existence and validity of arbitration agreement and jurisdiction of the tribunal shall be determined by the tribunal itself. But the caveat is, at the end of the day, even if we obtain a favorable award in favor of our client, it comes down to the issue of enforcement. And before that, there will be set-aside proceeding that may take place at Chinese court. So even if the tribunal exercises power according to the specific agreement between the parties, and also the competence principle, the Chinese court who will hear the set-aside proceeding and also enforcement proceeding may nonetheless deny the jurisdiction of arbitrary tribunal. But we can think of and come up with a contractual language to address this issue to the maximum extent. Thank you.
Okay, well, thank you for that answer. I hope that was helpful. It was helpful for me, at least. So we have another question from Bronwyn Lincoln. Thank you for the question. And this is a question directed to Joel. The question goes like this. Have the Singapore Mediation Convention and COVID combined to create a perfect storm for cross-border mediation? Will we see an exponential increase in mediated settlements? So the question is to you, Joel.
Thank you. That's actually a very good question. I think the SIMC had already been aggressively promoting mediation, both through events targeted at the legal and commercial communities in different countries throughout Asia, as well as joint venture agreements with institutions in other countries throughout Asia to promote mediation, which I think was having some effect. And was increasing both awareness and interest in mediating disputes. And I know SIMC is very new, in at least in the terms of the arbitration world, where we talk of institutions that are many decades old, like the KCAB itself and HKIAC. But SIMC has already seen an increase. SIMC has seen a significant increase in disputes over the last few years. And then the question arose, is COVID a pro-mediation factor that will make it more common because there are more disputes and parties want to settle them efficiently and quickly? Or is it contrary, that mediation really is a very personal thing, that you need to be in the same room as the other party and the mediator, and COVID prevents that? I think SIMC has very effectively answered that by instituting a special COVID protocol that's currently it's scheduled to be enforced through the rest of this year, ending at the end of this year. But it remains to be seen if it'll be renewed if the COVID situation continues, because it's not limited to COVID related disputes or disputes arising from COVID, but really is intended to provide dispute resolution through mediation that's appropriate to the current situation. And that is through reduced fees, expedited appointment of mediators, expedited facilitation of the process, and special arrangements for virtual mediation. I have to admit, I was somewhat skeptical at the start of whether this virtual mediation really was going to be effective or popular, and I have to say that I've been proven wrong. SIMC has, I've discussed with them actually recently that they have seen a significant increase in mediated disputes this year. And despite the virtual setting of the mediation, their success rate or settlement rate is relatively constant. So they're seeing many more disputes, and they're being roughly the same level of effectiveness in settling disputes. Now, I think mediation is something that is self-reinforcing. If you mediate and it's successful, then your next dispute, you're more likely to try to mediate, because it's indisputable that if you have a successful mediation, for the parties, that's a much better result than arbitration. You've saved a lot of time and cost. And I think a lot of the skeptical or hesitance to mediate is parties aren't sure that it's going to be successful. So the fact that more parties are having successful mediations now, in my view, is something that will carry over. And even in the post-COVID world, if we 6 months, a year, 2 years, however long it is from now, we're back to relatively normal. I think parties who have found success in mediation will remain advocates of mediation. So I didn't think at the start that this was, if anything, I thought it was the opposite, that it was the perfect storm against mediation. But I think it's proving to be a boon to mediation, which I think is extremely beneficial to the international commercial community.
Okay, thank you. Thank you for that. I think we have one last question, and this is again a question related to mediation. So if Joel's up to it, here goes a question. It's a question from Man Seng Young. Thank you for the question. And the question goes like this: do you have any experience to share on evaluative approach in mediation? So Joel, if you want to take that question.
I will say I've never been in a strictly evaluative mediation. What I have experience with, I think, is something that became somewhat of a hybrid, although it started with the intent to be facilitative. And that is a dispute between an extremely large American company and a very small Korean company. The American company, and I'll say at the outset that the American company was my client in that dispute. And they came into this dispute at the start of an arbitration asking, okay, when do we mediate? When do we send our mediation request? Because essentially in the US, virtually all disputes at some point go through at least some form of formalistic court mediation. And there's an assumption that you should always give mediation a try. I spoke with counsel on the other side who were representing the Korean party, and their client was far less receptive to the idea of mediation. And it took some convincing. It took actually some work from our client to wait for a point in the arbitration until the other side felt that they were at the highest point they could be. They had just filed their main submission, and we came to them and said, okay, why don't we mediate now? Because they wouldn't feel like that was a power play from us. If anything, they would feel like it was coming out of a place of weakness. And that's what it took to get them to the mediation table. We retained an extremely experienced, one of the most highly regarded mediators in Singapore, who did a fantastic job managing the process, the personality disputes between the CFO of a multi-billion-dollar company in the US and the sole owner of a multi-million-dollar company in Korea, who came from very, very different places as far as experience and expectations. And it started out with the intent to be a facilitative process. At some point along the line, I think the mediator realized that's not what the Korean party needs, that's not what they're used to for mediation. And unless he would push each party a little, it wouldn't move forward. So it became a more of an evaluative process where instead of asking each side, what do you see as the weaknesses of your case? I think he realized that our client felt like the other side wasn't willing to do that and wasn't willing to state their weaknesses, and our side wasn't going to be the only one. So our client was unwilling to openly discuss what the weaknesses were. So the mediator came in to each room separately, and on our side, I know he did, and I imagine he did on the other side. He said, okay, this is a private conversation. I'm not going to share anything unless you tell me I can. But here's what I think are your weaknesses. Here's what I think are your concerns. Can you tell me what you think of these concerns? Do you agree that they're concerns? Are there other concerns that you should also be taking into account? And I think, again, you would be less likely to see that in a US mediation where the mediator would try to elicit that information from the party. This mediator, where he wasn't getting that from the parties, took a more evaluative approach. And eventually, by the end of the day, I think we reached a settlement number at about 6 p.m. on a full day, signed a settlement agreement just after midnight. And finally, at around 5 o'clock, when he was realizing the day is running short and we're not that far apart, but we're not moving, he started actually proposing to each side, okay, what about this? What about this settlement term? What about this agreement that's the middle on this other term where you're in dispute? And I think it was a good balance of the facilitative and evaluative approach, which may be necessary if you have one party that's very entrenched in the evaluative approach and one that's very familiar with the facilitative approach.
Okay, well, thank you for sharing that. I think we are now at the end of our webinar, and I think some may have questions that they would like to pose to speakers, but we'll send you an email to all the participants. We'll send you an email with further information on how to contact the speakers, and also with a thank you note for participating in this webinar. So with that, I'd like to thank you all again for giving your time and to listening to us, and that I hope you'll enjoy the rest of the Hong Kong Arbitration Week, and see you again in other events. All right, thank you. Have a good day. Bye-bye.